Question 1. Topic: Perfection of security interests. Temporary perfection in proceeds in multi-location scenario where consistency of requirements must be met. Financial institution lends $500,000 to retail company secured by the company's inventory. The lender properly files a financing statement covering all inventory, whether now owned or hereafter acquired, and all proceeds. 6 months later, the company sells $100,000 worth of inventory and the proceeds are deposited into the company's general deposit account. The lender does not take any action to perfect its security interest in the deposit account. 3 months after the deposit, the company files for bankruptcy. What is the status of the lender's security interest in the $1,000 proceeds? A. The lender maintains perfected security interest in the proceeds because it was perfected in the original inventory. B. The lender loses its security interest in the proceeds because perfection in inventory does not extend to cash unless separately perfected. C. The lender's security interest in the proceeds remained perfected for 20 days but became unperfected thereafter because no further action was taken. D. The lender automatically perfects in pros indefinitely if the original inventory was properly perfected. Answer: C. The lender's security interest in the proceeds remained perfected for 20 days but became unperfected thereafter because no further action was taken. Explanation: under UCSS 9.315d, secured party automatically has perfected interest in identifiable proceeds of the collateral for 20 days. However, after the 20-day period, the security interest in proceeds remains perfected only if new filing covers the proceeds are cash proceeds that remain identifiable, or the proceeds are the same type as the original collateral, e.g. inventory for inventory. Here, the proceeds were deposited into general account, meaning they commingled with other funds. The lender failed to perfect in the deposit account, which requires control agreement or bank control, so perfection lapsed after 20 days. Is incorrect because perfection in inventory does not permanently extend to all proceeds. B is incorrect because the lender initially had temporary perfection in the proceeds. D is incorrect. Perfection in inventory does not automatically perfect in proceeds indefinitely. Separate perfection method must be used. This question tests the temporary perfection of proceeds and the need for further action to maintain perfection beyond 20 days. Question 2. Topic: Priority of security interests. By an ordinary course of business, during comprehensive review of process that needs improvement, wholesaler of high-end furniture grants security interest in all inventory, whether now owned or hereafter acquired, to bank in exchange for $2 million loan. The bank properly files a financing statement. Later, the wholesaler sells $30,000 luxury sofa to an individual consumer in routine retail transaction. The buyer has no knowledge of the security agreement. The wholesaler then defaults on its loan, and the bank claims the right to repossess all inventory, including the sofas, to the consumer, who has priority in the luxury sofa, and why. A. The consumer buyer has priority because they qualify as buyer in ordinary course of business by conduct rules. B. The bank has priority because its security interest attached before the sale. C. The bank has priority because the buyer did not file financing statement. D. The buyer takes the sofa subject to the bank's security interest because consumer goods are not exempt from attachment. Answer: A. The consumer buyer has priority because they qualified as a buyer in ordinary course of business by conduct rules. Explanation: under UCSS 9.3208, buyer in ordinary course of business by takes free of perfected security interest even if they know of the interest, as long as they purchase from seller engaged in the business of selling goods of that kind. B. Buying furniture from furniture retailer, the purchase is in good faith and without knowledge that the sale violates the rights of another party. Here the consumer bought the sofa in the normal course of the retailer's business without knowledge of any security interest violations. This makes them buyer, which gives them priority over the bank's security interest. B is incorrect because buyer rules override the bank's earlier perfection. C is incorrect because financing statement is irrelevant to consumer buyer's rights. D is incorrect because consumer goods bought in the ordinary course are protected from existing security interests under buyer rules. This question tests the interaction between secured parties and buyers and highlights UC's policy of protecting consumers in routine transactions. Question 3. Topic: Default and remedies. Commercial reasonableness in collateral disposition. While analyzing the root causes of sequential problems in secured lending, secured lender repossesses industrial machinery from defaulting debtor and chooses to sell it at private auction rather than a public sale. The lender provides notice only to the debtor and sells the machinery to an affiliated company at price significantly below market value. The debtor challenged the sale, arguing that it was not conducted in commercially reasonable manner. Under Article 9, what factors will court consider in determining whether the sale was commercially reasonable? A. Whether the lender obtained the highest possible price for the collateral. B. Whether the lender followed commonly accepted market practices in selling similar machinery. C. Whether the debtor agreed to the private sale in the original security agreement. D. Whether the lender was the highest bidder at the private auction. Answer: B. Whether the lender followed commonly accepted market practices in selling similar machinery. Explanation: under UCSS 9610, secured party disposing of collateral must conduct the sale in commercially reasonable manner. Sale is commercially reasonable if it follows accepted industry standards for similar transactions, even if the price obtained is not the highest possible price. Key commercial reasonableness factors include notice to interested parties, UCSS 9611, following standard market practices for similar asset sales. Using an arm's-length transaction, not selling to an insider at reduced price, is incorrect because the highest price is not the sole factor. Market conformity matters more. C is incorrect because debtor cannot waive the requirement of commercial reasonableness. D is incorrect because self-dealing, selling to an affiliate, raises concerns of faith and conflicts of interest. Question 4. In a high-stakes environment where multiple challenges arise regarding the enforcement of security interests, a bank extends a loan to a business secured by the company's accounts receivable. The bank files a financing statement in the appropriate jurisdiction. Subsequently, the company secures additional financing from different lender, granting this second lender security interest in the same accounts receivable. The second lender does immediately file financing statement but enters into an agreement with the company allowing the lender to collect on accounts directly from customers. Several months later, the company defaults on both loans. Both the bank and the second lender claim priority interest in the accounts receivable. Who has the superior claim and why? A. The first bank, because it was the first to file financing statement, giving it priority over subsequent claimants. B. The second lender, because it gained control of the accounts receivable through direct collection, which is superior method of perfection. C. The first bank, because its security interest attached first, and attachment determines priority under Article 9. D. The second lender, because it had an authenticated agreement with the debtor, direct collection, making it an automatically perfected secured party. Answer A. The first bank, because it was the first to file a financing statement, giving it priority over subsequent claimants. Explanation: under Article 9, priority in security interests is generally determined by the first to file or perfect rule, UCSS 9322. Lender that properly files UCON financing statement gains priority over later secure parties who have not perfected, in this case the first bank filed financing statement before the second lender took any action to perfect its interest. While control can be an effective perfection method for certain collateral types, such as deposit accounts or investment property, it is not method of perfection for accounts receivable UCSS 9104. Instead, accounts receivable must be perfected by filing or in limited cases by automatic perfection if purchase money security interest (PMI) applies, which does not apply here. Thus, despite the second lender's ability to collect directly, it did not perfect its interest through filing, meaning the first lender's perfected interest takes priority. This highlights the critical importance of filing financing statement in secured transactions. Question 5. While investigating a complicated issue between different creditors, a retail business purchases inventory from a supplier on credit. The supplier retains a purchase money security interest (PSI) in the inventory and properly files a UCON financing statement. Separately, the business has a long-standing secured loan from a bank secured by all of its present and future inventory, which was perfected by an earlier fine statement. Months later, the business fails to pay both the supplier and the bank, who has the superior claim to the inventory. A. The bank, because it filed its financing statement first, giving it priority over later creditors. B. The supplier, because a properly perfected ESI in inventory has special priority over prior inventory security interests. C. The supplier, but only if it also took possession of the inventory upon default. D. The bank, because its security agreement covered both present and future inventory. Answer: B. The supplier, because a properly perfected EAI in inventory has special priority over prior inventory security interests. Explanation: the purchase money security interest (PSI), a special type of security interest that allows a creditor who finances a debtor's purchase of goods to obtain priority over existing secured creditors (UCSS 9-324). However, to obtain priority over existing inventory, PSI creditor must perfect its interest at the time the debtor receives possession of the inventory, give written notice to previously perfected secured creditors before the debtor takes possession of the inventory. If these conditions are met, the PAI has priority over an earlier security interest in inventory even if the earlier interest covered both present and after acquired inventory. Therefore, the supplier wins priority in this scenario. Question 6. During a major transformation where existing methods of collateral enforcement are being tested, a secured party wishes to repossess equipment from a defaulting debtor. The debtor refuses to surrender the equipment, claiming the secured party cannot repossess without court involvement. The secured party, relying on Act rules, attempts to take possession of the equipment without judicial intervention. What are the secured party's legal rights? A. The secured party may repossess the equipment using self-help provided it does not breach the peace. B. The secured party must obtain court order before repossessing the equipment, as self-help is prohibited under the Act. C. The debtor has the right to deny repossession until the secured party provides at least 30 days written notice of seizure. D. The secured party may use force or intimidation if necessary to recover the equipment, as long act in good faith. Answer A. The secured party may repossess the equipment using self-help provided it does not breach the peace. Explanation: under UCSS 9-609, secured party has the right to take possession of collateral after default either without judicial process, self-help, or through court order. However, self-help repossession is only allowed if it does not breach the peace, meaning no violence, threats, or force can be used. If the debtor act resists or if repossession would require trespassing onto private property unlawfully, then the secured party must resort to judicial action, such as replevin, to recover the collateral. This rule balances the rights of creditors to recover collateral with legal protections for debtors, preventing excessive force or intimidation in secured transactions. Question 7. When scaling up operations that experience significant financing needs, a company enters into multiple secured transactions involving deposit accounts. One lender perfects its security interest by filing a financing statement. A second lender, however, perfects by obtaining control over the deposit account. Later, the company defaults. Who has priority? A. The lender who filed a financing statement because it perfected its interest first. B. The lender with control over the deposit account because control is the preferred method of perfection for deposit accounts. C. The lenders must share the collateral equally since they both perfected their interests properly. D. The lender who made the larger loan as greater financing takes priority under the Act. Answer: B. The lender with control over the deposit account because control is the preferred method of perfection for deposit accounts. Explanation: under UCSS 9-327, security interest in deposit account can only be perfected by control, and lender with control has priority over one that merely files financing statement. Control is obtained in 3 ways. The secured party becomes the bank's customer on the deposit account. The party and bank agree that the lender has control. The secured party maintains the account itself. Since control is the strongest method of perfection for deposit accounts, the lender who obtained control has superior rights, regardless of filing order. Question 8. In a high-stakes business dispute involving a secured transaction, a company purchases specialized manufacturing equipment using a loan from lender A, which perfects its security interest by filing a Aquan financing statement. Later, the company refinances the loan with lender B using the same equipment as collateral. Lender B also files a Aquan financing statement but fails to conduct a lien search. The company on both loans who has the superior claim to the equipment. A. Lender A, because it was the first to file a Aquan financing statement, giving it priority over later creditors. B. Lender B, because a refinancing lender automatically takes priority over earlier creditors under the UC. C. Lender B, because the debtor reaffirmed the security agreement with lender B, making it the most recent secured creditor. D. The lenders must share the collateral equally as both have perfected security interests. Answer A. Lender A, because it was the first to file a Aquan financing statement, giving it priority over later creditors. Explanation. Under UCSS 9322, priority in security interests is based on the first to file or perfect rule. Because lender filed its Aquan financing statement before lender B, it maintains priority. Even though lender B provided refinancing, lender B could have negotiated subordination agreement with lender to gain priority, but failing to conduct lien search meant it unknowingly took junior position. This situation highlights the importance of due diligence in secured lending and the risks of assuming priority without proper verification. Question 9. During a critical financial restructuring, a business grants a security interest in its accounts receivable to two different lenders. Lender X files a financing statement immediately. Lender Y, unaware of lender X's filing, perfects its interest later. When the debtor defaults, both lenders claim the accounts receivable. Which lender has the superior claim? A. Lender X, because it filed first, giving it priority under the UC. B. Lender Y, because accounts receivable automatic it perfect at the time of the security agreement. C. Lender Y, because it had direct agreement with the debtor regarding collection of accounts. D. The lenders must share the accounts receivable proportionally. Answer A. Lender X, because it filed first, giving it priority under the UC. Explanation. Per UCSS 9322, when two secured parties have competing security interests in the same collateral, priority is determined by the first party to file or perfect the security interest. Accounts receivable must be perfected by filing, meaning the lender that files first has priority, even if the second lender was unaware of the first. Unlike deposit accounts, which require control for perfection, accounts receivable are governed by filing rules, making the first filed creditor the superior claimant. Question 10. When scaling up operations, a business enters into multiple secured transactions involving deposit accounts. One lender perfects its security interest by filing a financing statement. A second lender, however, perfects by obtaining control over the deposit account. Later, the company defaults. Who has priority? A. The lender who filed a financing statement because it perfected its interest first. B. The lender with control over the deposit account because control is the preferred method of perfection for deposit accounts. C. The lenders must share the collateral equally since they both perfected their interests properly. D. The lender who made the larger loan as greater financing takes priority under the UC. Answer. B. The lender with control over the deposit account, because control is the preferred method of perfection for deposit accounts. Explanation. Under UCSS 9327, security interest in deposit account can only be perfected by control, and lender with control has priority over one that merely files financing statement. Control is obtained in three ways. The secured party becomes the bank's customer on the deposit account. The party and bank agree that the lender has control. The secured party maintains the account itself. Since control is the strongest method of perfection for deposit accounts, the lender who obtained control has superior rights, regardless of filing order. Question 11. In a high-stakes environment where multiple challenges arise regarding the enforcement of security interests, a lender perfects a security interest in a debtor's inventory. Later, the debtor sells the inventory to buyer in the ordinary course of business. Can the lender still enforce its security interest against the buyer? A. Yes, because the lender's security interest remains attached to the collateral even after the sale. B. No, because buyers in the ordinary course of business take free of perfected security interest. C. Yes, but only if the buyer was aware of the lender's security interest at the time of purchase. D. No, because the lender should have required the debtor to obtain written consent before selling the inventory. Answer. B. No, because buyers in the ordinary course of business take free of a perfected security interest. Explanation. Under UCSS 9320, buyer in the ordinary course of business, buyer takes goods free of security interest, even if it was perfected and known to exist. Buyer is buyer who purchases goods in good faith without knowledge that the sale violates another security interest. Buys from seller engaged in selling goods, e.g. retail store selling inventory. Since the inventory is meant to be sold in the ordinary course of business, lenders assume the risk that secured inventory will be sold, which is why they rely on proceeds rather than repossessing inventory. Question 12. During a complex corporate merger, Company A and Company B both claim a security interest in the same collateral, a fleet of delivery trucks. Company A perfected its interest first by filing a Aquan financing statement. However, Company B, unaware of this filing, later provided financing and perfected its interest as well. The debtor defaults, who has priority in the collateral. A. Company A, because it filed first and priority is determined by the first to file or perfect rule. B. Company B, because it provided financing more recently and therefore has an updated security agreement. C. The lenders must split the collateral equally since both have perfected security interests. D. The debtor's choice determines which lender has priority. Answer A. Company A, because it filed first and priority is determined by the first to file or perfect rule. Explanation. Under UCSS 9, 322A1, when multiple creditors claim security interest in the same collateral, priority is based on the first party to either file or perfect the security interest. Even though Company B was unaware of Company A filing, priority is not based on knowledge. It is based on the timing of perfection. Company earlier filing gives it priority over Company B. This highlights why it is crucial for lenders to conduct a clean search before extending financing. Question 13. When resolving disputes over the enforceability of security interests, a lender claims a security interest in equipment leased to a business. However, the lease agreement contains a clause stating that the equipment remains the property of the lessor. The business defaults on its obligations. Can the lender enforce its security interest against the lessor? Yes, because the lender's security interest extends to all assets controlled by the business. B. No, because the lessor retains ownership under the lease agreement and the business never had rights to grant security interest. C. Yes, but only if the lender can prove that the lease was actually disguised security agreement. D. No, because security interests in leased goods are automatically void. Answer. C. Yes, but only if the lender can prove that the lease was actually a disguised security agreement. Explanation. Under UCSS 1, 203, if lease is actually disguised security interest, then the lessee business is treated as the owner and the lender's security interest can attach. Courts consider several factors, including whether the lessee is obligated to buy the equipment at the end of the lease, and whether the lease payments cover the full of the equipment, whether the equipment has little or no value at the end of the lease term. If these factors suggest that the lease is functionally secured transaction, then the lender's security interest is enforceable. Otherwise, the lessor retains ownership and the lender cannot claim the equipment. Question 14. During a financial restructuring, a lender perfects a security interest in a company's inventory. However, another lender claims that it has an automatically perfected purchase money security interest, PI, in the same inventory. Who has priority? A. The first lender, because it perfected its interest first. B. The PI lender, because PMSIS in inventory have priority if proper notice is given. C. The lenders share the inventory equally. D. The debtor determines which lender has priority. Answer. B. The PSI lender, because PMSIS in inventory have priority if proper notice is given. Explanation. Under UCSS 9, 324, B. Purchase money security interest, PSI, in inventory has priority over other security interests if the lender perfects the PAI before the debtor receives the inventory, sends notice to prior secured parties before the debtor receives the inventory, PAI in non-inventory, e.g. equipment does not require notice, but for inventory PMSIS, notice is mandatory to gain priority over earlier filed security interests. Question 15. In a high-stakes legal dispute, a secured lender has a perfected security interest in a debtor's equipment. However, bankruptcy trustee argues that the lender's interest should be invalidated due to technical filing error. What is the likely outcome? A. The lender loses priority because any filing error renders a quon statement ineffective. B. The lender retains priority if the error is minor and does not mislead searchers. C. The lender automatically loses its interest in bankruptcy proceedings. D. The trustee gains control over the equipment regardless of filing rules. Answer. B. The lender retains priority if the error is minor and does not mislead searchers. Explanation. Under UCSS 9506, minor error in a quon financing statement does not affect its validity unless it makes the statement seriously misleading. Courts typically uphold security interests unless the error prevents reasonable searcher from finding the filing. Common minor errors that do not invalidate filing include misspelling debtors slightly but still searchable, omitting punctuation mark, however, major errors, e.g. wrong debtor name, a missing collateral description can render the filing ineffective, allowing bankruptcy trustee to invalidate the security interest. Question 16. When multiple parties claim an interest in A debtor's accounts receivable who has priority. A. The lender who filed first, because accounts receivable security interests are governed by the first to file rule. B. The lender with purchase money security interest, because PMSIS always take priority. C. The lender who notifies the account debtor first. D. The lender who extended financing most recently. Answer A. The lender who filed first, because accounts receivable security interests are governed by the first to file rule. Explanation. Under UC SS 9.322, priority for security interests in accounts receivable is determined by the first to file rule. Secured lender must file a UC financing statement to perfect its interest. The first lender to do so gains priority over later claimants, even if later lender was unaware of earlier filing. Question 17. During a corporate liquidation, a lender claims a security interest in the company's intellectual property, but the bankruptcy trustee argues that the interest was not properly perfected. How should the lender have perfected its security interest? A. By filing a financing statement with the State Secretary of State. B. By obtaining control over the intellectual property. C. By recording the security interest with the U.S. Patent and Trademark Office or U.S. Copyright Office. D. By notifying the bankruptcy court before the company's insolvency. Answer C. By recording the security interest with the U.S. Patent and Trademark Office or U.S. Copyright Office. Explanation. Unlike most security interests perfected by filing, UC security interests in patents and copyrights must be recorded in their respective federal offices. Patents, U.S. Patent and Trademark Office, thus too. Copyrights, U.S. Copyright Office UC filing does not perfect an interest in federally registered intellectual property, making federal recording essential to enforceability. Question 18. During a commercial loan transaction, a borrower grants a security interest in its inventory to a lender. However, the borrower also has existing debt secured by the same inventory. The new lender perfects its interest by filing a UC financing statement. Which lender has priority in case of default? A. The lender who filed first, because UC rules follow a first to file or perfect priority system. B. The new lender, because its security interest was more recent and updated. C. The lenders must share the collateral proportionally based on their loan amounts. D. The debtor decides which lender has priority. Answer A. The lender who filed first, because UC rules follow a first to file or perfect priority system. Explanation. Under UC SS 9.322A.1, if multiple lenders claim security interest in the same collateral, priority is given to the first party to file or perfect their interest. Even though the second lender filed its UC financing statement, it is second in line to the first lender who previously perfected its security interest. The first lender has the superior claim unless the new lender qualifies for purchase money security interest (PSI) with proper notification to prior creditors. Question 19. When a secured lender fails to file a financing statement but has a security agreement signed by the debtor, what is the impact on the lender's priority in the collateral? A. The lender retains priority because signed security agreement is sufficient. B. The lender's interest is unperfected, meaning other perfected creditors will have priority. C. The lender can perfect its interest retroactively if it files later. D. The lender automatically loses its security interest. Answer B. The lender's interest is unperfected, meaning other perfected creditors will have priority. Explanation. Security agreement alone does not perfect security interest. Under UC SS 9.310A, perfection usually requires filing a financing statement with the Secretary of State. If lender fails to file, it still has valid security interest, but it is unperfected. Perfected security interests take priority over unperfected ones. In bankruptcy proceeding, an unperfected interest may be voided by the trustee. Filing UC is essential for protecting priority rights in collateral. Question 20. During a secured transaction, a debtor defaults on a loan secured by business equipment. The lender wants to repossess the collateral. What must the lender do to comply with UC Article 9 repossession rules? A. The lender must obtain a court order before repossession. B. The lender may repossess without a court order but cannot breach the peace. C. The lender can seize the collateral by any means necessary. D. The lender must notify the debtor before repossession. Answer B. The lender may repossess without a court order but cannot breach the peace. Explanation. Under UCSS 9609, lender has the right to self-help repossession without court order only if it does not breach the peace. Breach of the peace occurs if the repossession involves force or threats, occurs over the debtor's objections, requires unauthorized entry into private property. If peaceful repossession is not possible, the lender must seek order to reclaim the collateral. Question 21. In a financing arrangement, a debtor grants a security interest in its accounts receivable. Another creditor claims a conflicting interest in the same accounts. What determines which creditor has priority? A. The first to file a UCON financing statement. B. The first creditor to notify the account debtor. C. The most recent secured creditor. D. The creditor who extended the largest loan. Answer A. The first to file a UCON financing statement. Explanation. Under UCSS 9322A, priority in accounts receivable is determined by the first secured party to file financing statement or perfect their interest. Even if later creditor has more recent agreement, the first lender to file UCON has priority. Notification to the account debtor is relevant in factoring arrangements, but it does not override filing-based priority rules. Question 22. When a lender provides financing secured by a debtor's deposit accounts, how must the lender perfect its security interest? A. By filing a UCON financing statement. B. By taking control of the deposit account. C. By sending notice to all creditors. D. By obtaining the debtor's consent. Answer B. By taking control of the deposit account. Explanation. Under UCSS 9104, security interests in deposit accounts can only be perfected by control, not by filing UCON. Lender gains control by becoming the deposit account holder, entering into control agreement with the debtor and bank, being the depository bank where the account is held. Control gives the lender priority over other claimants. Question 23. When a debtor grants a security interest in consumer goods, under what circumstances is a financing statement required? A. Always, since all security interests must be perfected by filing. B. Only if the goods are worth more than $5,000. C. Only if automatic perfection does not apply. D. Never, because consumer goods are exempt from UC rules. Answer C. Only if automatic perfection does not apply. Explanation. Under UCSS 9309-1, purchase money security interest PMCIS in consumer goods are automatically perfected upon attachment. However, automatic perfection does not apply to motor vehicles must be perfected by title registration. Fixtures must be perfected by filing. For most consumer goods, filing UCON is unnecessary unless they are exceptions to auto perfection. Question 24. When a debtor changes its name after a lender has filed a UCON financing statement, how does this affect the lender's perfection? A. The lender's perfection remains valid indefinitely. B. The lender's perfection remains valid for 4 months, after which new filing is required. C. The lender must immediately file new UCON. D. The lender loses perfection automatically upon the name change. Answer B. The lender's perfection remains valid for 4 months, after which new filing is required. Explanation. Under UCSS 9507C, if debtor changes its name, previously filed UCON remains effective for 4 months. After that, the lender must amend the filing or risk losing perfection in new collateral acquired after the name change. Question 25. In a secured transaction, a debtor sells collateral to a buyer. Under what circumstances does the buyer take the collateral free of the security interest? A. If the secured party consents to the sale. B. If the buyer is a buyer in ordinary course of business. B. C. If the sale price exceeds the value of the secured loan. D. If the buyer was unaware of the security interest. Answer B. If the buyer is a buyer in ordinary course of business. B. Explanation. Under UCSS 9320A, buyer in ordinary course of business buyer takes free of security interest if the buyer purchases goods from seller in the business of selling such goods. The sale occurs in the ordinary course of the seller's business. However, buyer protection does not apply to buyers of farm products from farming operation. Question 26. During a secured transaction involving intellectual property IP, a lender perfects its interest by filing a UCON financing statement with the Secretary of State. However, another creditor claims a superior interest in the same IP, citing a previous federal trademark filing. How does priority work in this case? A. The UCON filing governs, as UC rules apply to all security interests. B. The federal trademark filing governs as federal law supersedes UC rules. C. The first creditor to file under E. The system has priority. D. The lender must refile in federal court to perfect its interest. Answer B. The federal trademark filing governs as federal law supersedes UC rules. Explanation: intellectual property security interests are unique because perfection depends on the type of IP involved. Copyrights require filing with the U.S. Copyright Office. Patents and trademarks require filing with the U.S. Patent and Trademark Office as the general IP. E.g., trade secrets may still fall under UC rules. F. A lender only files a UC financing statement for IP. Its security interest may be subordinate to a party that properly perfected under federal law. Question 27. When a debtor grants a security interest in inventory but then sells that inventory to a customer, what happens to the lender's security interest in the sold goods? A. The security interest remains attached to the goods even after the sale. B. The security interest is automatically extinguished upon sale. C. The security interest remains, but the lender must file new UC statement. D. The security interest continues unless the buyer qualifies as buyer in ordinary course of business. Burke. Answer D. The security interest continues unless the buyer qualifies as a buyer in ordinary course of business. Burke. Explanation: under UC SS 932, a buyer in ordinary course of business buyer takes goods free of security interest even if the interest is perfected. However, if the buyer is not buyer G. Purchasing inventory for resale rather than personal use, the lender's security interest attached to the goods. For example, retail customer buying TV from store takes free of the lender's security interest. Wholesaler buying shipment of TVS may still be subject to the lender's claim. Question 20. If a debtor defaults on a secured loan and the lender wishes to dispose of the collateral, what must the lender do under UC rules to ensure a commercially reasonable sale? A. The lender must conduct a public auction. B. The lender must provide notice to the debtor and other secured parties. C. The lender can sell the collateral immediately without any notice. D. The lender must sell the collateral at fair market value. Answer B. The lender must provide notice to the debtor and other secured parties. Explanation: under UC SS 9611, secured party must provide reasonable notice before disposing of collateral. Notice must be sent to the debtor, any other secured parties with an interest in the collateral. The sale must be commercially reasonable, meaning it is conducted in recognized market or by commonly used methods. The price reflects fair market value, but it does not have to be the highest price possible. Failure to comply with notice and commercial reasonableness can result in liability for damages or loss of the lender's deficiency claim. Question 29. A creditor perfects a security interest in a debtor's equipment. Later, the debtor moves to another state. What must the creditor do to maintain perfection of its security interest? A. Nothing, as the original UC filing remains effective indefinitely. B. The creditor must file new UC financing statement in the debtor's new state within 4 months. C. The creditor must file termination statement and refile the entire agreement. D. The security interest is automatically lost upon the debtor's move. Answer B. The creditor must file a new UC financing statement in the debtor's new state within 4 months. Explanation: under UC SS 9316A 2, when debtor relocates to another state, the secured creditor's interest remains perfected for 4 months. To maintain perfection, the creditor must file new UC financing statement in the new state within the 4-month window. If not refiled, the security interest becomes unperfected. Priority to other creditors. This rule ensures that creditors can track security interests across state lines while giving debtors some flexibility to move. Question 30. If a lender has a perfected security interest in a debtor's inventory and the debtor obtains additional inventory after the security agreement is signed, does the security interest automatically apply to the new inventory? A. Yes, if the agreement contains an after acquired property clause. B. No, the lender must file new UC financing statement. C. Yes, but only for 30 days after the new inventory is acquired. D. No, after acquired property is never covered by security interest. Answer A. Yes, if the agreement contains an after acquired property clause. Explanation: under UC SS 9204A, security interest can automatically attach to after acquired property if the security agreement explicitly states so. Common in inventory and equipment financing, this clause ensures that lender's interest extends to new inventory or assets acquired after the loan is made. The lender does not need to file new UAC each time new inventory is purchased. After acquired clauses do not apply to consumer goods unless the debtor acquires them within 10 days of the secured party giving value.